The topic for today that we have is criminal investigation, leaps and bounds. Now, why do the organizers call it leaps and bounds? Is that leaps and bounds? It is usually used in phrases that you may grow by leaps and bounds. 2 days back, rather yesterday itself, we had the occasion of Guru Purnima, where gurus may have blessed their disciples that you may grow by leaps and bounds. What do you mean by leaps and bounds? It's a Shakespearean phrase or terminology where a person may jump and spring the faster as he can. That is leaps and bounds. So why do the organizers call this topic of investigation, that to criminal investigation, as leaps and bounds? Because the CRPC wished so. It was the code of criminal procedure that wanted, that desired that investigating officers should function by way of leaps and bounds. And it should, in fact, conduct and complete the investigation in a time bound manner as per the provisions of the CRPC. And hence, leaps and bounds. I am really not here to conduct a lecture as such on the CRPC or on the Evidence Act, because I firmly believe that we don't have that much of time to have a lecture on CRPC or on the Evidence Act, probably some other day. And secondly, I think law professors in the law colleges are more competent than me or any other lawyer to teach you the provisions of the CRPC in the academic provision, in the academic province. So what do we invite you here for? We invite you here for two things. Let us go little deeper into chapter 12 of the CRPC and let us brush our basics. How does an investigation really proceed? Second, which is more interesting, and hence I keep it a little later. Desserts, I believe, are to be kept after lunch or dinner, so we keep it a little later. That is the 226 jurisdiction, which is often resorted to. Now, what is 226 jurisdiction? It is the writ jurisdiction of the Honorable High Court. You see, every day in newspapers, you must be reading that whenever there is an FIR, may it be a bigger FIR or a smaller FIR. By way of bigger FIRs, I mean bigger accused persons having a reputable name. And smaller FIRs, I mean by ordinary men suffering from FIRs, suffering from crimes which get registered against them, probably because of their blame or otherwise. Now, whenever FIRs get registered, the first thing that comes to a common man's mind is to protect himself from arrest. There is a growing tendency among citizens that they directly go and approach the High Court. And I feel very sorry to say this. There is a growing tendency amongst law professionals to suggest their clients that let us file a writ petition in the High Court and let us challenge that FIR, which is a very bad practice. I believe that if you know your basics well, you will never suggest the client to go to the High Court unless it is an ex facie illegal, ex facie malafide FIR. If it is so malafide that it is alone the High Court, it is only the High Court that can interfere with it, only then I as an advocate of yours would suggest that let us go to the High Court and get it quashed. We'll come to that a little later. Now, the Supreme Court has taken a very stern view, but then that has been widely misinterpreted, not only by law students, not only by lawyers, not only by judges, but academicians as well, which I find really strange. Let us come to that. We'll clarify that position, but first we'll have a look through the provisions of the CRPC. But before that, I would like to share with all of you, just 5 minutes or 10 minutes before I could log in into this program, I received a phone call from somebody who is a client of mine. I'm prosecuting a criminal appeal of his, final hearing criminal appeal of his in the High Court. He called me with respect to some other matter today. What he said is that yesterday somebody came into his police, he's a jewelry owner. He has a jewelry shop in Pune. The police officers came to his shop. They entered into his shop with an informant who barged into his shop. The first informant, the complainant, said that I had stolen a ring worth 400 grams or whatever odd grams. Let us consider 400. I had stolen a ring and I had sold it to this man, this jeweler. And he knew it, that it was a stolen ring. Still, he purchased it from me. That is what the police come to him. They take him to the police station. He is telling to the police that I don't know who this lady is. She has never come to my shop, but they don't listen to him. They go to the police station. They take him to the police station. He is made to sit for the entire day. And then they tell him that you are supposed to give us a recovery of 400 grams of gold. Only then we will leave you. Otherwise, we are arresting you under so and so provision. Oh, what does a common man do in this case? This is something which is so malafide on the face of it that you don't know who the woman is. You don't know just because you own a shop selling jewelry. Somebody comes to your doorstep, says that I have so and so allegation against you, against which the police take you to the police station, get a recovery without a panchanama, and then he is left. Tomorrow he might apprehend. Tomorrow the client will apprehend that somebody will again come to his door and tell him, we are arresting you for so and so offense that you have committed. What option does he have? And that is the reason basic knowledge of these provisions is required. The first thing that I was telling my client, why didn't you call me up? He's calling me up today after he gives a recovery from his own pocket of 400 grams of gold, of whatever worth. This is something very much malafide, and hence 226 jurisdiction is required in such cases. Otherwise, I won't suggest anybody. You see chapter 12 of the CRPC. Little fundamentals of it. One is information. Second is investigation. So unless the police receive information from somebody, right or wrong information, but when the police receive an information, they will evaluate it. They will apply their own mind. They will understand it. And then against the provisions of the Indian Penal Code or any other statutory criminal law, they will see whether that allegation fits into an offense. Once it fits into an offense, then the investigation would start. Now, the investigation would not start unless there is an information which is recorded into writing by way of systematic study. So the police conduct a systematic study of the subject. They examine you as an informant, and then they register an FIR. The informant goes to the police station under section 154, and he says that so and so are my allegations against so and so person. Please get an FIR registered against him. Now, what if it is a non-cognizable offense? I hope you all know what are cognizable and non-cognizable offenses. Cognizable offenses are those where the police can immediately take cognizance. In other words, in common man's language, I will tell you that these offenses are serious in nature. Not that all offenses which are not cognizable are non-serious in nature, so to say, but then these offenses are ordinarily serious in nature. And hence the law requires that you don't wait for anybody's permission to go and get that person arrested. You directly go and get him arrested if his arrest is so necessary. So that is a cognizable offense. Offenses like murder, offenses like rape or dacoity, or offenses of these kind are cognizable. Even the one which my client might get arraigned with, that is 411, which is dishonestly receiving stolen property. That is the allegation against him. It is a cognizable offense. So if it is a cognizable offense, the police are bound to investigate. The police are entitled, please listen to this word very carefully, the police are entitled to arrest, but not duty bound to arrest. There's a difference between having a right to do something and it being a duty to do something. If it is a right, it involves a choice. I have the choice to pick up a book from here and start reading it. But it is not my duty to read the book, unless, of course, the case requires so. That apart. So it is an entitlement. It is the right of the police. You see section 41 of the CRPC. The section 41 says that the police shall have the right to arrest you. It is an entitlement, as I said. Later on, 41 capital A was added, and that is very interesting. Of what 41 capital A says, that in case of certain offenses where the police feel that arrest is not necessary because the accused is not going to run anywhere or for other reasons, the police are entitled again to send a notice under section 41 capital A of the Code of Criminal Procedure. Now that notice says that we have received so and so allegation against you, against which we have registered an FIR against you. Mr. So and so or Mrs. So and so, please come to the police station on the said date and please answer all the questions to our satisfaction. Now, if I fail to answer that as an accused person, if I fail to answer to that, or if I fail to respond to that, then there is an apprehension of arrest. Now, in a similar way, so suppose if you go to the police station and the police refuse to register an FIR. Now, we have spoken much about the rights of the accused persons. Let us little come to the rights of the informants, the first informants, complainants. I go to the police station and tell the police that so and so are my allegations. Please register an FIR. The police say, no, sorry, we don't find any sense in these allegations. You go back home. We are not going to look into it. These appear to be civil offenses. These are not criminal offenses. We are not going to look into it. Sorry, mister, go back. Do we have any option? Police feel that it is not a cognizable offense. They feel that they should not investigate into it. They feel that it's a waste of time to look into these allegations. Do you have any option against that? Answer is yes. You can, in fact, under 154, go in an appeal kind of a provision. It's not an appeal, but it is an appeal kind of a provision where you can go to the superintendent or the commissionerate. In cities like Bombay, Pune, Nagpur, you will find the commissioner of police, but in other cities, you will find it as a district superintendent, which is usually known as the DSP, the district superintendent of police. So you can go to that particular authority and tell that authority that so and so is my grievance. Despite setting it out, the police have refused to register it. Please do something against it. It may even happen that the DSP or the commissionerate refuses to do so, refuses to direct the police station for any reasons whatsoever. What is the option after that? Please go and see section 200 of the CRPC. 200 says that if you go with a private complaint to a magistrate, then the magistrate, after examining the merits of your matter, can direct the police authorities to register an FIR on the basis of those allegations. Suppose your fate is not that good with the magistrate also. What happens thereafter? The magistrate says that no, boss, we don't find any sense in these allegations. Go home. The police were right, the commissioner was right, the SP was right. Your options have not faded. You always have the option to invoke 226 jurisdiction of the High Court. Now, please pay attention. What I mean to tell you is that when an advocate suggests you that go and approach the High Court under 226 because that is the only right remedy, he is wrong unless there are grave facts. But he is wrong, sorry to say this, because if you have basic knowledge, common knowledge of these provisions, ordinary provisions under which you can approach A, B, C, D authorities, what is the need to trouble the High Court under a wider jurisdiction like Article 226? And you know about alternative remedies, efficacious remedies. If an efficacious and equal remedy is available, then the High Court would be justified in rejecting your prayer, and the High Court would be justified in telling you that please go back to the authority based under the CRPC. Nothing wrong with the High Court. Now, again, if you go to see provisions, there are so many provisions where the police authorities have the right to summon you. They have the right to call you to the police station, whether you are the informant or not. Even if you are the if potential witness, they have the right to call you to the police station and tell you that give us information about so and so offense because we are investigating it. Now, in these situations, what happens is that there is some protection granted to elderly persons, some protection granted to women, and some protection granted to minors. So if you are a minor, by minor I do not mean minor as per the Minority Act or the Juvenile Justice Act. If you are a minor in terms of the CRPC, that is less than 15 years, or if you are an old man above 65 years of age, or if you are a woman of any age, women are entitled to have concessions again under the CRPC. Thankfully so. So you are protected from being called before the sunlight and after sunset. These are basic provisions which not only as lawyers but as common men, as common citizens, which we should be aware about, we ought to be aware about, without which there happens to be an abuse of the process of law, and then only and only sufferance comes to a man's fate. That being so, I do not really want to bore you with reading the provisions of the CRPC because the more interesting part, as I was telling you, is a little ahead. Of course, if you have any doubts with the provisions of the code, you can always have them in the discussion, provided they are dealing only with the investigation part as of today. So you see, the investigating officer plays a major role in this investigation. In fact, he is even called as the arm of the investigation. ARM, arm of the investigation. And suppose if this investigation is to be stultified, if it is to be stopped at an interim stage, that you please don't investigate into this, what happens? There are so many witnesses which are waiting to be examined. They cannot be examined because you cannot investigate into that offense. There is evidence which at some point of time may be perishable. That evidence cannot be looked into, it cannot be examined, it cannot be sent to the forensic laboratory for evidence examination because investigation has been stultified. Who does stultify this investigation? Again, this 226 jurisdiction. And now we come to the interesting part. Few months back, there was a Supreme Court judgment by the name of Niharika Infrastructure versus State of Maharashtra. I'll give you the citation, Criminal Appeal 330 of 2021. It's a very interesting judgment, and I found it really very interesting because it was at that point of time that I was into such kind of matters which involved exactly the same point of law. I'll tell you how. One of my clients was a beneficiary of an order of the High Court, where the High Court felt that an FIR against him is an abuse of the process of law, and hence it should be stayed. The investigation in the FIR was stayed, and High Court ordered that he should not be arrested. No coercive steps should be taken against him. By way of malafide, the investigating officer goes to some different police station and he gets a different FIR registered against my client on the same allegations, saying that FIR A has been stayed, but I am not prevented from registering a new FIR on the basis of the same allegations in a different police station. So see how cleverly he does it. The High Court says that don't go ahead with the investigation because we are staying it. What he does is, all right, he keeps it in the fridge. He goes to some different police station, or he calls up some different police station and tells that policeman that please register a new FIR on the same subject, an identical FIR, and please go into this investigation. This is not only an abuse of the process of law, but this is clear contempt of the court, where in order to disrespect the orders of the court, where in order to overcome the stay which has been granted on the investigation, you register some different FIR and show it to the court. Oh, it was a different FIR, so we can investigate into it. Sorry. So we said to the High Court in a different petition that in that FIR we have a stay. In this FIR also we want a stay. And if not a stay, then please protect us from arrest. We will cooperate with the investigation. What happens after that? The High Court grants us a relief in terms of no coercive steps should be taken against the applicants or the petitioners. What do you mean by no coercive steps? That the applicant should not be arrested. I was really wondering, suppose in a 226 writ petition, which is a petition challenging the FIR in its entirety because it is bad in law, how could the writ court protect me from being arrested? Because as I was telling you, that this general remedy of a High Court is not to be utilized when you have existing statutory remedies. Now, when I open the CRPC, I see that there is something known as anticipatory bail. That is bail in anticipation of arrest under section 438 of the code. Now, when I open 438, it says that the district court, the sessions court, shall have the authority to grant you bail in anticipation of arrest, or the High Court, a single judge of the High Court shall have the right to grant you bail in anticipation of arrest so that nobody arrests you, but then that doesn't stultify the investigation. Investigation can go on, but I remain outside. I was just wondering this, that if the power is vested to grant protection from arrest with the sessions court or the district court or a single bench of the High Court, then how can a quashing bench sitting in a division bench, how can a division bench grant me the same relief? That was a question which I was muttering upon. Shortly so, the Supreme Court judgment comes which says that the High Court should refrain from granting reliefs in terms of no coercive steps. What do the high courts do? This came as a shock that the high courts are not supposed to protect men or protect petitioners who come to them with an FIR, challenging an FIR, which is ex facie bad in law. So the High Court cannot do it. Relegate the parties to the Sessions Court. Now, the facts of the case may be different in Niharika's judgment because there, what had happened, the petitioners had approached the Sessions Court. The Sessions Court had refused anticipatory bail. And then they approached the High Court under 226 and said that please grant us the same relief, which is not possible. Then the High Court even said this, that all right, we are dismissing your petition because we don't find any sense in this petition, this challenge to the FIR. Let the investigation go on. But we are granting you the relief in terms of protection from arrest for a period of 6 weeks from today. So we are dismissing your petition, but at the same time, we are extending the interim relief that has been granted to you. How fair was that? That was the question before the Honorable Supreme Court. Now, the division bench of Honorable Justice Chandrachud and Justice M.R. Shah, Justice M.R. Shah has authored this judgment very beautifully and very particularly. But then that has unfortunately created some confusion amongst the law fraternity and also the academic fraternity. What is the real confusion about? What the Supreme Court said, that the court should not thwart any investigation. The court should not stop any investigation if it pertains to a cognizable offense. Now, sorry, but every investigation pertains to a cognizable offense. And even if it pertains to a non-cognizable offense, how does that matter? Secondly, the Supreme Court said that, I'll just read out, it's so interesting. It is only when no cognizable offense is disclosed or offense of any kind is disclosed in the FIR that the court will not permit an investigation to go on. What does that mean? That if an offense is not seen in the FIR, it is only then the courts would not permit the investigation to go on. Otherwise, the court would not do anything. Court, as in the high courts, would not do anything. Now, this was widely misinterpreted by high courts all over India. I was informed by so many of my friends all over India that they are experiencing confusion at the heads of the high court judges, which are not able to interpret this judgment so properly. And mainly this happened so because the Supreme Court had directed by way of the same order that a copy of this order be circulated amongst all high courts. And hence it was like a direction that please follow this. And otherwise also the arbiter of the Supreme Court, the ratio of the Supreme Court has to be binding. But then I come to my first point, that if the investigation reveals that it is a cognizable offense, then the courts are not to stay the investigation. I don't understand the logic of this. Every investigation is going to disclose a cognizable offense, whether it is truthfully so or not so truthfully, but it is going to disclose a cognizable offense. No dispute as to that. Suppose somebody makes an allegation of 376, that is rape, or let us take the best example of 354, which is sexual harassment to a woman. Probably that maybe can be a false allegation or a concocted allegation. But then just because it is a cognizable offense, would the High Court stop itself from going into the validity of the FIR, the validity of the quashing petition, the validity of the challenge? Answer is no. So how do you interpret this? You interpret this by saying that if it relates to a cognizable offense, which prima facie appears to be true, it is only then the courts would stay its hands off and the courts would refuse to grant reliefs. It is only then. Secondly, how do we interpret the later part? That if it discloses an offense, then no, sorry, the High Court will not look into it. No, if there is no prima facie case made out in the quashing petition, if there is some sense in the FIR which the High Court judges, the division bench of the High Court can see, then the High Courts, and only then the High Court should refuse. Otherwise, if no sense is seen, if the FIR appears to be prima facie concocted, if it appears to be vague and non-specific, it is the duty of the High Court, not the choice, but it is the duty of the High Court to stop the investigation then and there by way of an interim relief. Supreme Court said that the High Court should be slow in granting such interim reliefs. Why? Because you consider the right of a winning party or a party which wins the interim relief. But think something about the right of a losing party, that is the state or the informant. What must be on him when an interim relief in terms of no coercive steps or in terms of stay on investigation is granted in favor of the applicant accused? What happens? So the other party, in fact, has the right to challenge that order. It goes up to the Supreme Court. Now, Supreme Court should be in a position to find out what weighed with the High Court, what has the High Court considered in order to grant such a relief. And that is what the Supreme Court says in Niharika. The Supreme Court says that the High Court is not prevented from granting such relief. The High Court under 226 can very much grant it. What we say is that please record reasons, because reasons are the essence of every judgment. Unless reasons are recorded in detail, thorough reasons are recorded, how do we find out what has weighed with the High Court? How do we find out whether the High Court judges were right or wrong in giving this relief in terms of stay on investigation? Now, unfortunately, the Supreme Court in this has missed one point. That is the judgment of, again, the Supreme Court of 2012. That is Imtiaz Ahmed versus State of UP. Now, what does that judgment say? That all right, high courts can grant stay, high courts can prevent the arrest of the accused, high courts can even go on to say that don't file charge sheet unless we tell you. That all that is fine. But then these stays should be for a limited period. Because what happens that when the investigating officer is asked to stay off his hands from the investigation, what the problem that arises is that, as I was telling you, the main problem that arises is that the investigation would suffer. The investigation would suffer, the cause would suffer, and the witnesses who are with you today, who are with the prosecution today, they might go with the other side. It's very much possible in the practical arena. They might go with the other side, or they might remain with nobody. It's even possible that the evidence which is available, which should have been examined at that point of time, even though it is not perishable, but if the evidence is not examined at that point of time, then in the later course, you give a clear loose hand to the accused to claim equities on the basis of that, which should not be the case. And hence, the High Court should stay its hands off to grant these reliefs that are stays on investigation, unless a very excellent case is presented before the High Court. But despite presentation of such an excellent case, if the High Court refuses to grant that relief, then sorry, it has abdicated its duty. I must say this. And that was so far as investigation is concerned. Let us speak little about trials. There are situations, there are events where the trials are even stultified. The High Court said that you don't go ahead with the trial unless we tell you to do so. The trial is stayed till next date. Then the next date goes on extending and it goes on. So the trial is stayed for 5 years, 7 years, 10 years, 20 years. When does this happen? You are put to trial. Now, before the trial, there are certain stages. You see 226 of the CRPC. What 226 of the CRPC says that you can, in fact, apply for discharge in the trial court. Discharge as in these charges make no sense. The charge sheet that has been filed against me makes no sense. So please release me, because in law, not on evidence, but in law, I do not fit into these offenses. Suppose if the trial court releases you on discharge, it discharges you of the charges, well and good, you be happy. But if it refuses to do so, what people usually do, they go in a revision petition, a revision application as they call it, under 397 of the CRPC to the High Court. And then usually, as a matter of course, the High Court, if it is to grant a stay on the trial until the revision application is decided, then it becomes very problematic for the trial to go ahead, because there is a stay on its activation. Even that defeats the process. So it is only in exceptionally excellent cases, I would not call in only rarest of the rare cases, but only in exceptionally excellent cases, this should be stultified, and this should be a measure in the rarest of the rare cases and in deserving cases. Rarest of the rare case doesn't mean in the minimum possible cases. It should be in deserving cases and well-founded cases on merits. So the Supreme Court had said in Imtiaz Ahmed 2012 judgment of Justice Kapadia, it said that it is only for a period of 6 months that you can stay something. May it be a trial or may it be an FIR, an investigation. It is only for a period of 6 months. But then I don't understand, many of them probably are not aware of the 2012 judgment, and it is more disregarded than being honored. So it is there on paper. We need to learn it and we need to implement it as practitioners of law. Now, of course, you conveniently forget that judgment and you forget the ratio of 6 months if you are the accused person's advocate. But then you remember this judgment when you are the prosecution's advocate because you don't want the trial to be stayed. You don't want the investigating officer's activities to be stayed qua investigation. So, this is how it goes. If you see the civil procedure code, there is a concept of injunction where, or under order 39 rule 1, if the court injuncts from doing something, then you cannot go ahead. The respondent party or the defendant parties cannot go ahead. Similar is the logic with these stays, that the high court grants a stay in the nature of an injunction akin to order 39 rule 1 of the CRPC, and then you cannot go ahead with it. But then what the Supreme Court in Niharika says, that you go ahead with it, no problem. In deserving cases, please go ahead with it. But if you want to protect him from arrest, let it be an exceptional case to utilize 226. Listen to this carefully. Let it be an exceptional case under 226. Otherwise, please don't protect him. Tell him to utilize his statutory remedy under 438 and let him get an anticipatory bail by the Sessions Court. Secondly, don't stay the trial, don't stay the investigation unless it is required to do so in the interests of justice. And that is the language used by 482 of the CRPC. What does 482 say? That it is only to meet the ends of justice, to prevent the abuse of the process of law. These wide powers have been conferred not by the Constitution, but by the CRPC itself. The CRPC is in existence, although may not be an identical provision which we see today, that is 482. But then the CRPC is in existence much, much prior even to the Constitution. So the authors of the CRPC were aware about the powers which are to be conferred upon the High Court, and of course the limitation which the Supreme Court has laid down today. So you record reasons. Again, I'll take you to the CPC, where the CPC says that under order 40 in rule 2, the court is to record reasons for every issue. Same logic you apply over here, that the court, may it be the High Court, it is to record detailed and thorough reasons while granting interim relief as well as while refusing interim relief, so that when you go to the higher forum, that is the Supreme Court judges will be in a position to understand as to why and what has weighed with the High Court to grant such reliefs or to refuse such reliefs. Now, one can really go on and on with this topic because it's a huge topic, as I was telling you in the beginning. If you see chapter 12, it is a bunch of 22 provisions, but then it covers the entire arena as to how investigation, which is such a beautiful but at the same time difficult aspect to go into, with a matter of 22 provision, it covers that as to how investigation is to be conducted, and then it travels to the next chapter, that is chapter 13, as to how inquiries and trials are to be conducted by courts. We go back where we started because the circle is to be completed, where I started by saying that the topic of this lecture is criminal investigation, leaps and bounds. Leaps and bounds, I was telling you that let it be fast, let it be time bound. Now, when I say time bound, the police are given a particular timetable that within 60 days or within 90 days, as the case may be. For some offenses, it is 60 days, which are punishable for less than 10 years. You read 167. For some offenses which are punishable with death or life imprisonment or more than up to 10 years, or rather more than 10 years, then it is 90 days. Now, suppose the investigation cannot be completed within 90 days pursuant to the accused going into magisterial custody or 60 days, then you get a default bail entitlement. You get an entitlement to claim default bail, that I was in the custody of the police, I was in the custody of the magistrate. They should have investigated the offense. For 14 days, I should have been into the custody of the police. 14 days, after the 14 days period, I have been in the custody of the magistrate. So many days, 90 days or 60 days. Please calculate this period and release me on bail. Even that entitlement is given under the CRPC. So what do we gather by all this? That yes, investigation is a procedure which has to go on with a different sense of alacrity, with a different sense of speed, and hence timelines, timetables, so to say, have been laid down in the CRPC. If you don't follow that as an officer, as an investigating officer, as an arm of the investigation, then you give the right to the accused to get released on bail. So far, so much. I think this is a topic which can be much understood by way of wider discussions. So I await your questions. If you have any questions, you can speak them out or you can write it in the chat box. Thank you very much.
There's a question, Arjun. Can a investigation be stayed and quashed in the same petition?
Investigation be stayed and quashed in the same petition? Of course, that is the very jurisdiction of the High Court. That there are different prayers. One is that I don't know, but as advocates, one would get to learn that in a petition, which is a typical quashing petition, as they call it colloquially, in a quashing petition, the first prayer is that you should quash the FIR. Second prayer is that you stay the investigation. Third prayer is that protect me from arrest. Fourth prayer is that let the charge sheet not be filed. And fifth prayer is grant me anything that you can in order to protect me. So everything and anything can be claimed for under a 226 jurisdiction. What to be given is the prerogative of the High Court.
Sir, what is the leading evidence to prove that the FIR is false?
Whether the FIR is false or not, it is a question of trial. You will have to face the trial, you will have to examine the witnesses, get yourself examined, examine the first informant, then only you can satisfy the trial court that the FIR is false. But there might be situations where ex facie, on the face of it, it appears to be false. There are so many situations where a woman alleges that there has been harassment with me by this man on so and so day. That is her allegation in the FIR. Suppose if the High Court is to see this, that you were not even in Mumbai, where she has mentioned that on so and so date he harassed me by touching my body or touching my private parts. You were not even in Mumbai, but you were somewhere else in Delhi or Kolkata. Is that not a strong basis, at least prima facie, to show that this allegation is false? You were not even present to touch her. So falsity can be proved in front of the High Court under 226 only by showing such facts or such things. But where detailed consideration of evidence is required, I am sorry, and I'm really afraid you will have to go to the trial court and face evidence.
Sir, what about the judiciary overstepping the functions of the executive?
The judiciary overstepping the powers of the executive. In fact, I am a strong believer into separation of powers. It should not be done. That's correct. But then there are so many instances where, if not the judiciary, then whom is the question. So it is only the judiciary that can act and direct, if not the executive. Then it has to do something. Otherwise, we are helpless.
I had a question vis-a-vis investigations. If somebody who wants to make a complaint which comes under the IPC, and let's say, for instance, under the Domestic Violence Act, but that person is not residing in Mumbai, but it is against an Indian citizen, can that complaint be initiated over email, writing to the police station?
There are facilities. In fact, if you see 154 of the CRPC, it says that you can initiate and, in fact, activate the criminal investigation by way of an oral complaint or by way of a written complaint. And in fact, Mumbai police, I don't know about police belonging to other cities. Probably there is a portal for Maharashtra police also, which is an umbrella portal. But then you have the facility of lodging an EFIR to the police station. So that facility is always there.
All right. Thank you.
What is the time limit for re-investigation or further investigation by the police?
As per the court's discretion, equal amount of time can also be granted. So a further period of 90 days can even be granted by the court. It is completely as per the court's discretion.
So Arjun, Swati is asking that if a woman has accused a person with mental health, how can the police protect the woman?
And investigation also, because that's the main thing, because then only they will help. Otherwise, there's not going to be any progress.
But is there an offense just because you have a mentally ill man in your house? You cannot go to the police station and tell that I have an apprehension that he will beat me someday. Is there an offense that has taken place? Otherwise, it's a mere NC. It's a mere NC under 504 and 506 of the IPC. It's a non-cognizable offense where the police will take NC, and if the magistrate is satisfied that yes, you should look into it, only then the police will register an FIR.
Okay, so
Otherwise,
that means a private complaint, really.
not a private. It's not a private complaint. It's a non-private complaint, I would say. Private complaint is to the magistrate under 200, where all your options go to the water. If you go to
Okay.
say where you have no options at all, you are alternativeless, then only you will go to the magistrate under 200. Otherwise, nobody prevents you, if an offense has really taken place, from going to the police station and registering an FIR if it is a cognizable offense.
So, can additional charges be made in the FIR, and what is the procedure?
You call invocation of provisions, because charges is a term which you use only qua the charge sheet after investigation is completed. So let us call them, can additional provisions be invoked in the FIR? Certainly they can be invoked. There are instances where a rape accused or an accused of a victim of rape or a victim of some sexual harassment is very reluctant to reveal certain instances that have taken place. She may reveal only part of the instances where so and so allegations have been referred to and provisions as per that have come to the fore. But after some time, as the earlier participant was asking us, after some time she might gain some confidence to go again to the police station and tell that so and so has happened with me. The police are then duty bound to add additional charges in the later point of time. But then, I have seen advocates for the accused persons, including myself, who take disadvantage of this situation by saying that, oh, this charge was added later on, so this provision was invoked later on, so this is an afterthought, and hence I should be released on bail, or else I should be protected by way of anticipatory bail. So keep in mind, accused, in fact, informant should bear in mind that you please reveal the entire version, whatever is true, to the police, so that the police can apply their mind and have all the provisions invoked, whichever is suitable to the case of the victim, so that you don't give an opportunity to the devil's advocate, to the advocate for the applicant or the accused, to take disadvantage of this situation and term this as an afterthought.
The next question is, what is the process of acquiring the FIR copy from the police?
So the police won't provide you with an FIR copy. You will have to go to the magistrate, the local magistrate, the jurisdictional magistrate, and apply it with the registry, the office of that particular magistrate. The police are not duty bound to provide you a copy. In fact, they are duty bound to provide a copy to the informant, the first informant, but not to the accused person. The accused will have to make an application in the magistrate court with the registry. It is only then you will get a certified copy of the FIR.
Can a right to information application help in acquiring the FIR copy?
I am afraid no, it cannot, because one is that it is in dispute, it is arguable whether it will be a public document or not. Secondly, if there is a statutory mechanism by way of which you can acquire the RTI, the FIR copy, then why would an RTI, which is a special law, assist you in acquiring it? You have a way, you have an alternative way.
Many of our students are either they have graduated now, or they are in their final years, but they can't find internships. So they how can they invest their time or channelize their time just now sitting at home to make the most out of it?
I firmly believe, when I was a student of law, I invested most of my time either into reading or into mooting. I hardly studied for my exams because I never got time to study. But still, I used to score well because of my moots, because of the practical experience that I used to gain in moots. I somehow used to manage in my exams also. So most of the time of mine, I used to invest into moot courts, which today, unfortunately, cannot be the case with students. And even if they try to invest their time into moot courts or any such activities, they are just at home because everything has become so virtual and online. So they cannot really spend much time, invest much time into anything, because they have a lot of time with them. So I would in fact suggest that internships, but I don't know how I really can't imagine how internships, that to virtual internships, help students. I have seen students where they get work or assignments of writing something or drafting an article. This is what my junior colleagues tell me who are yet in law school. My friends tell me that this particular lawyer or this particular firm, they have asked us to draft an article for themselves. They have asked us to research. All that is fine, but then there are, limitations upon this virtual practice, virtual internships. So I really don't find anything beneficial. I may be wrong, please correct me if I am. I would be happy to know I am wrong, but then I really don't find any such practical benefit with this online internships. So what I would suggest my friends, especially junior colleagues, is this: that enhance your knowledge on law by reading, rereading, and again reading the same thing. Because when the provisions of law that you study, you can understand at this particular age by way of course, Supreme Court and High Court judgment, that will really help you. So far as research is concerned, which online internships give you, make the most out of it, get the best out of it, because otherwise I don't see a better option with this lifestyle in this mode of internship. And now we speak only of cities where you have internet available, you have Wi-Fi available, you can sit under the AC, you can sit under the Wi-Fi for 24 hours and operate your laptops. But then what about areas where there are no facilities of internet? Forget laptops and computers. How do law students, because you have surviving law students over there also, how do they manage to have their internships or even the learning or study? I gather, I even have friends over there in these areas. What I gather is they just go on reading in the libraries or in their home libraries or even online. They just sit and read and try to research more as they can. And mainly as a student of law, what I find is people do not update their knowledge. Updation of knowledge is really very important. I don't know how many of you were even aware about this Niharika's judgment. How many of you were even aware about that there is a provision in the CRPC by way of which an anticipatory bail should be sought, and instead people go to the High Court and say that please protect me from getting arrested. So this is something that is new, novel, which you should update yourself with. Of course, times will come when all this will go, COVID will go away. Probably, I just hope for that. Everything will go away, life will become normal. But then, till then, if you are not a law student and you come into practice, then I really don't know how much. Secondly, attending these webinars, seminars, talks, etc. I was just surfing LinkedIn a while back before this lecture. Somebody had put a beautiful post on that. They said it had put a Supreme Court's picture, lawyers walking in the corridor, and that gentleman was saying that no lecture or no law school will teach you how to practice. But then I would like to take an exception to this particular lecture that I seek to conduct and I seek to discuss, that this discussion is certainly going to help you with your practice, because this nobody is going to teach you. Whatever I have discussed with you today was not from the books. I have not read a single provision. I have not prepared for this lecture at all. It is just the Niharika's judgment that I have studied. I had written an article also on that a month back or so. It is just the judgment that I have studied, and coupled with that is the practical knowledge that I got to gain because of such opportunities, because of such matters that came my way. It is only then you can learn all this. So I really don't understand how online internships are going to help in these days. But then the best that you can do is update your knowledge with all possible opportunities.
So, Arjun, can you share with the participants how do they approach CPC and CRPC, the study material, or is there any approach to mastering the Civil Procedure Code and the Criminal Procedure Code?
I don't know how to gain mastery because I have myself not gained it yet. But then what I would rather give a little suggestion is that you start reading from provision number one to provision number whatever, so from A to Z, because that is how it will teach you. Not that it will ensure that your memory will retain provision A to Z. It is never possible. I can't remember all the provisions. Probably there might be more intelligent individuals who can by heart all these provisions. I am not concerned with them. I respect their knowledge. I respect their memory. See, when you go to a lawyer as a client, the client expects you to know the law. That's fine. But what more the client expects you to is to apply logic, and that logic should be able enough to find out where does the law stand. You should be able enough. Now probably you can see so many books behind me. As a lawyer, I am not expected to know each and every word in these books, but as a lawyer, the client would expect me to go to the correct book at the first step and find out the law which is applicable to your case. This is what is expected. Now, in order to gain a mastery over the CPC or a CRPC, you require practice into that. Reading the book, attending classes may not help that much. You require good practice into that. Suppose you see, in a plaint, if there is a defect or if there is some updation of facts, then you go to the court and tell the court that I want to change it. In law, we call I want to amend it under so and so provisions of the CPC. That's fine. But then, how many of you know that against this order of mere granting of the amendment, you can, or the losing party or the aggrieved party can challenge that very order into the High Court under a 227 petition? How many of you know that? The impression that usually law students carry is that only final orders can be challenged and interim orders cannot be challenged. You would never see the High Court unless it is a final order or it is the end of the trial. Otherwise, you won't see the High Court. That is not the case. Even a mere granting of an amendment application can be challenged by the losing party before the High Court under a 227 petition. So what I mean to tell you is that unless you get such opportunities by way of your internships and when you come into practice by way of such matters, you won't gain a mastery into these laws. Because knowing the law, knowing the provisions from the book is a different thing. But knowing the application of those laws is a completely different aspect, which you will learn only with time. There is no hurry. Final year law student may not know what under what provision bail is granted, may not know under what provision anticipatory bail is granted, what is remand, what is police custody. Final year law student probably may not know what is order 14 rule 2, what is order 39. But then when he comes into practice and he's dealing with such cases, if that he doesn't know how to apply, then that becomes a sorry state of affairs. So what I mean to tell you is that sincerity is a must when such responsibilities come to you. So wait for such responsibilities, enjoy your time as a student. There's no hurry to learn everything because it can't be learned in a hurry. So enjoy your time, enjoy your research, enjoy these studies, and the right time will come when application of these laws are to be made. And then when you apply these laws in real life, when you apply these laws in your draft and tell the judge that this under so and so provision, so and so should be the benefit to my client, it will never go away from your head. I bet you on that. It will never go away from your head. Again, you will not have to see the book. Oh, what is the provision under which my client was once benefited?
Can you suggest any online resources for criminal law?
Refer the books, and mainly there are very good commentaries on criminal law on the CRPC. You see Paranjpe's commentary on the CRPC. Then there is one Kelkar. Kelkar has a very good commentary. There is one commentary which is very less known. It is by a senior advocate Shrikant Bhatt, who is today no more. But Shrikant Bhatt was a very leading practitioner in criminal law in the Bombay High Court. Many of you may not know this, but then one of my relative, he had challenged the constitutional validity of Section 309 of the IPC, where attempt to suicide should not be criminalized. His name was Maruti Shripati Dubal. You may have read about this matter. Shrikant Bhatt had argued it so skillfully in the Bombay High Court that Justice P.B. Sawant had struck down the constitutional validity of 309. It was then carried to the Supreme Court, which was overturned for other reasons. But then you must just see the knowledge that Shrikant Bhatt had carried while arguing the validity of 309. You will see it in the judgments. His arguments are recorded. Now that man has written a commentary. When I was a student of law, I had asked the principal of the college to order for that commentary. It was very rare. It was not available. So order for that commentary from somewhere. So it was in my college library since I agitated for it. So you must read these books, these rare books, where the application of law by these unusual authors is tremendously beautiful. where you won't find these things on the websites and on the web.
Thank you so much, Arjun.
Thank you very much. It was a great pleasure speaking to all of you.